obtained from the UDW, as we used to call it.
at that time.
You started your legal career in the Department of Justice as a junior administrative clerk,
That's correct.
and worked your way, became a prosecutor, magistrate, and a regional magistrate, which is where you are now in 2006.
That is correct.
So you've been a regional magistrate since 2006.
That is correct.
All right. You have several acting stints at the KwaZulu-Natal division of the High Court, starting in January 2015.
That is correct, Deputy.
When you collate all those terms, what do they come up to?
22 terms.
How many written judgments have you produced during those acting stints?
49 criminal judgments, 12 appeal judgments, 6 civil judgments, and 4 review judgments.
Any taken on appeal?
The last count were 3.
Have
On
they
appeal.
been finally decided?
The 2 were confirmed convictions and sentences. The 4 of the 6 convictions were confirmed, 2 were set aside, but the sentence remained the same.
All right. Do you have any reserved judgments?
No, not at all.
Okay. You've written a book titled Confident Criminal Litigation,
That's correct.
but you wrote it under an alias. Why is that?
I'm generally known as Anand Maharaj. It's the nickname.
Oh,
the
I
calling
see.
name.
All right. No, I'll save this question for later. Let me just hand
Thank
over
you.
to the commissioners to put questions to you. AJP Matondo?
Thank you, DCJ. Afternoon, Mr. Maharaj. Good evening.
Good evening,
Yes.
Acting JP.
Though we've been together the whole day, I will have a few questions for you. If you are appointed, would you say your appointment enhanced transformation? If the answer is, how?
My answer would be yes. How would be is that I consider myself to be South African. I consider myself to be part and parcel of the South African population in terms of racial composition and gender. In that sense, I think that I would qualify in terms of Section 174 sub 2. Given the adjudication experience for the last 29 years from the district court, regional court, and the act instance in the High Court, I think I can bring that ability to the High Court. Transformation in the sense of constitutional transformation in terms of social justice and the decisions you make in the High Court can also be considered as transformation. So I believe I can do that.
Okay, will enhance diversity on the bench?
That's a difficult question in the sense that, you know, the Constitution talks about unity in diversity and that South Africa belongs to all in level. As I said, I'm part and parcel of the South African society, so I would think that I'm part of the diverse group as well.
What's your answer, maybe?
I would say yes, I'm part of the diversity of the country.
Yeah, but
In
taking
terms of
into
experience,
sorry.
in terms of the knowledge of the law, in terms of expediting matters, that would be my answer.
Taking into account or regard being had to the demographics of the division, the judges of the Indian origin seem to be overrepresented at the moment. What would you say to this?
That's a good question, Acting DJP, but my answer to that is that if you think of me as an Indian, I would ask to say, listen, think of me as a South African Indian. At the end of the day, I understand color, I understand diversity, but if you say Indian, 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 when do we reach a state of non-racialism that the Constitution speaks of? So that is the decision that falls for this commission to decide, of whether I reflect the imperatives in 174 sub 2 of the Constitution.
Thank you. Did you have any involvement in community or other organization? And if the answer is, what involvement? And with what community or organization?
The answer is yes. The community involvement that I consider as community involvement is the fact that I'm an avid blood donor. I've donated over 103 pints thus far, and would encourage people to become blood donors as well as platelet donors. To me, that is also serving the community in terms of helping those who need the blood. In terms of outreach programs, we've been to schools, several schools in fact, to teach youngsters about leadership qualities, the value of education, the value of respect for the teachers, and to consider that education is important for their future lives. I've also been fortunate enough to lecture, I think between 1999 and 2002, at the then University of Zululand, Durban Mlazi campus, where 90% of the students were African male and females, and they've done pretty well, I might add, after receiving their undergrad LLB degree. One in particular that I can think of is now Deputy Director of Public Prosecutions in KZN. In terms of community work, I would also consider the fact that one of our appeal clerks in the regional court, while doing the appeals, became interested in criminal law from reading the transcripts, studied, assisted her with the assignments in guiding her. She is now a prosecutor at the Durban court after receiving an LLB degree. In terms of community work, we've also called PLT students from the business sector to come and experience what court life is about. So they understand how the courtroom functions or how the law functions in a live debate. So those are some of the community things that we have done, or I have done.
Yes, thank you. The LSSA says that on the 29th of September 2011, you ordered the arrest and detention of Warrant Officer R. Nagasa simply because he happened not to be in court during the hearing of the case over which you presided.
That is correct. The circumstances surrounding that is the prosecutor informed the court that the witness was present. When his turn came to testify, he was no longer in court. He was not outside. He had received a subpoena. And on that basis, I issued the warrant pursuant to provisions of Section 187, 188 of the Criminal Procedure Act. He was subsequently arrested. I think he spent an hour incarcerated. Inquiry was conducted. He was exonerated and found not guilty because he had given the explanation that he had told the prosecutor that he was testifying in another court. He subsequently sued the state and myself. That case was dismissed against him with costs, as the court found that I acted within the confines of the law. So the point I want to make with that, he's not above the law. He may be a police officer. He received a subpoena. Prosecutor did not inform me that he was testifying in another court. And on that basis, I issued the warrant. Had she done so, I would have waited for him to testify and then come back to my court. So those are the circumstances under which I actually took the liberty of sending a copy of the judgment where the court dismissed his claim.
But the inference drawn there that on the part of the SA, that was an abuse of judicial power on your part.
No, with respect, there's not an abuse of judicial power if you're acting within the scope of the law and confines of the law. So I disagree with that.
Okay, thank you. Thank you, TCJ.
Thank you, HAP. Premier?
Thank you very much, TCJ. Good evening, Mr. Maharaj.
Good evening,
Please
Commissioner.
bring the mic closer to you so that we can hear you. Bring it closer. Yes, thank you. Mr. Maharaj, you've had a number of acting stints in the province, both in the Durban and the Pietermaritzburg centers. Last year, during one of your acting stints, you set aside a life imprisonment sentence against a young man who had raped a 9-year-old. Do you remember that case? Okay. And in that, you quoted in your judgment that the lower court had overemphasized the seriousness of the crime. And of course, there's other things that you said. Now, my question here is that, do you not consider a rape of a minor as an overly serious crime?
Just to be sure, the case you're referring to is Amakolo Paulus Kumalo
Yes,
at 141.
correct.
The conviction and sentence was set aside on the basis of the conviction was incorrect on the facts, as well as the conduct of the magistrate presiding at the trial. So regardless of the age of the complainant, if you looked at the record of what the magistrate had done to insult the accused, belittle him, that clouded his objectivity insofar as that was concerned. But on the merits itself, from the evidence of on record, the conviction could not be sustained.
But you proceeded to say there were compelling circumstances which included his youthfulness, the youthfulness of the perpetrator, the fact that the perpetrator was asthmatic and he had a low level of education, and there were no evidence of serious injury to the complainant or her emotional state.
Okay, no, I think we are cross purposes, my apologies. That is not one of the cases you're referring to in the bundle.
No, it's not on the
Oh,
document. It's just one of the cases that you
That was one of
presided
the
on last year.
cases that was, we went on the basis of State versus Velakazi, where the Supreme Court of Appeal held there are certain factors you can take into account to consider substantial and compelling circumstances in order to deviate from the prescribed minimum sentences. And that is what we did. You must appreciate, Commissioner, that it wasn't a decision alone. It was a decision with another judge. And we both agreed that was what we had to do.
No, I appreciate that, but the question I'm posing is, do you not consider a rape of a minor to be overly serious? Considering the fact that KwaZulu-Natal is the capital rape center, with Inanda police station having the highest numbers of rapes in the country.
Yes, it is serious. It falls into the upper echelons of seriousness where children are concerned. But I think, when it comes to the court deciding on the degrees of seriousness, I think that's where the problem comes in. And the court may consider that a rape of a 2-year-old child who has sustained injuries to be more serious than, say, someone who hasn't sustained and is an adult, although rape is rape and it's always serious. So the point I'm trying to make is if one looks at the degrees of seriousness, one would automatically say, listen, the rape of a child would be considered more serious. So we followed the opinion of Velakazi, which we decided that on these facts that the sentence should be interfered with.
So in light of this judgment and the judgment that Judge Mantondo was speaking on, can you see the discrepancy?
Yes.
And can you see when we look at your judgments, the fact that I might be correct in perceiving you not to be able to provide accurate sentencing or accurate judgment to an accurate matter?
That may be a perception, but with respect, I think that one must also consider how we arrived at that decision by taking into account, already decided cases from the Supreme Court of Appeal as well.
I don't agree with you. I think it was very negligent, and the fact that we have such serious challenges with the rape, particularly in that province and in eThekwini, I really do not agree with that. But DCJ, thank you.
Thank you very much, Premier.
Can I
Commissioner
make a
Malema?
quick follow-up, DCJ?
Yes,
If you don't mind.
Yes, of course, Commissioner Malema.
Say, when you're being told this is your judgment and you say no, it's not only mine, we authored it, we were two, and then I agree with it. Why do you bring that point? Does it make less of your judgment if you are two on that judgment?
Thank you for the question. The point I was making, Acting President, is that it's an appeal.
No, there's no problem, but we're saying she's referring to you, she's referring you to your judgment. And you say you must consider, I was not alone there, yet you agree with it, yet you are the judge who made that judgment. When you bring to our attention that there was another judge, does it make it less of your judgment?
No, it doesn't.
When there was another judge that you agree with?
No, it does not.
Okay, thank you.
Thank
May
you.
I also
Thank you,
comment?
DCJ.
Yes, Commissioner Breitenbach, is that you?
Yes, thank you, Mr. Judge. Thank you. Sorry for just shouting. Good afternoon, good evening, Judge. I'm on the virtual platform, sorry.
Well,
Oh, yeah, in the front.
they're not showing you even on the TV screen.
I'm sorry, I've got a really poor signal, there's lots of load shedding, and so I'm scared I lose connectivity. I'm trying to be on two devices.
No, that's fine, we can hear you.
Okay. You mentioned, sir, that one should consider the reasons why you interfered with the sentence. I'd like to hear those reasons because I tend to agree with the previous speaker that the rape of a child is unbelievably serious.
I don't have the judgment before me.
You don't
If I
remember?
recall correctly, the sentence was one of life imprisonment. The Court of Appeal reduced it to 25 years, and the reasons were given as to why I found substantial and compelling circumstances. So those are the reasons that I can only stand by and fall by.
Thank you.
Thank you, Commissioner. Commissioner Marumachai?
Thank you very much, Deputy Chief Justice. Good evening, sir.
Good evening, Commissioner.
Will I be correct to assume that criminal law is your specialty?
I would agree with that.
Yes. I just want to, I've been troubled by the Criminal Procedure Act, especially the schedules to it. I'm not sure how many schedules are there. Like
Seven.
Seven. When one looks at them, you see that they tend to repeat crimes.
In each
A crime will be repeated and all those things. I want to hear from your view, are these schedules properly structured to ensure that both the magistrate and the prosecutors do not struggle to quantify a particular crime, especially for the purposes of bail? That's the first question. The second one, when we go to Schedule 6, that really requires those exceptional circumstances. What is your view on that? How does one get to this concept of exceptional circumstances? Isn't it one of those things that are making it very difficult for people who might otherwise be deserving of bail to not be able to get bail? Just want to hear your views in relation to that.
It's a good question. The question of Schedule 6 in terms of the seriousness of the offense, and it comes to bail, and obviously the onus is on the accused person to establish exceptional circumstances for him or her to be released. This is the problem which came about with the legislature. the legislature decided to schedule these offenses. The legislature decided that these are the offenses that fall within the purview of Schedule 6. The interpretation of Schedule 6 is that not impossible to get bail. It's just that it's more difficult because of the offenses are considered to be serious. They wanted the courts to be more circumspect in taking factors into account to decide whether bail should be granted or not, especially, as you said, rape cases, murder cases, robbery cases, and things like that. So the fact that exceptional circumstances are there, it's a value judgment which the bail court dealing with has to make. You must appreciate the legislature has never defined what exceptional circumstances were. We rely on case law. We rely on cases from the Supreme Court of Appeal or the Constitutional Court to give the court an idea that, listen, these are the factors that may be considered exceptional. For instance, there's a weak case against the accused. Consider that exceptional, or he may have an illness, or he's not a flightless and he's put up a lot of money as surety. Perhaps that can be considered exceptional. So it's never been defined. I agree with you, the legislature needs to be more clear as to what exceptional circumstances ought to be, rather than leave it for the court to decide on case-to-case basis what would be exceptional circumstances.
We have loved to get your reaction on the schedule and the ordering, but for the sake of time, I will leave it there, DCJ.
Thank you, Commissioner. Commissioner Case?
Thank you, DCJ. Good evening.
Good evening, Commissioner.
I just want to take you to the objection that you received very late by Mr. Sitofile. Did you receive that objection?
Yes, yesterday at 5:30.
Yes.
Yes.
But the reason why that objection was allowed is because apparently even on your last interview, it was drawn to your attention. You were asked about it.
Yes, I did.
Now, Mr. Stoffel, I just only read this. Mr. Stoffel is saying, special attention is hereby drawn to the fact that on two numerous occasions, we previously objected to Mr. Maharaj being recommended to be appointed as a judge on the basis of very serious justifiable ground of having been very harshly slammed by the presiding judge in a most damning judgment against Mr. Maharaj on irrefutable, fraudulent, and corrupt hardcore evidence on record, and as such being the most damning and unchallengeable findings against him. And he attaches the judgment to this. The point is, that is my question, because I just do justice to Mr. Stoffel and to yourself. First, you accept that there were those findings made in that judgment, and what is your response to the commission in view of those findings made in the judgment?
The judgment that was attached, Commissioner,
Yes, he attached it.
it's not a full judgment in terms of some of the pages were missing, as I see,
Yes.
but I will accept that's the judgment of
Yeah.
the judge from there,
Judge Kuhn.
which was ventilated in the last interview in 2018. As I said, I don't agree with the finding, but I accepted it. I didn't appeal it as a result of the council deciding that, listen, accept it, move on, and that's what I did. But I don't agree with it, as I said before.
Yes. Look, the point...
And I don't know Mr. Stofile. I think the address is given from Mtata. I don't know the gentleman, never met him. And these complaints were given after the closing date, but I accept that you're entitled to ask on that. I don't have an issue with that, but I don't agree with that.
Yeah. No,
I'm sorry, what was the last part of your,
I said I don't agree with the judgment.
with which judgment? I'm sorry, I got distracted for a second there.
Sorry,
What is it you don't agree with?
I don't agree with what Mr. Stofile is saying, as well as I don't agree with the judgment of the court.
Oh, okay.
Yeah.
Both.
no, but the point, I'm sorry, I mean, it's just that I have to put this to you.
No, I don't have an issue with that.
The point is that there is a judgment, and in that judgment, there are findings made by that court, which prima facie suggest a corrupt in fact, a fraudulent conduct on your part,
like-
on the face of it, and they have not been set aside, they have not been appealed. So that's why I wanted you to have an opportunity on that. Thank you, CJ, that's it.
Thank you, Commissioner Nokiesi. Just a quick follow-up on this line of questioning. I was just curious to find out why you did not declare this incident in your questionnaire, because the usual thing is to mention such things and say if the case was withdrawn against you, or
I
if
did
you're
so in the
convicted,
last-
it was, you
Okay.
findings were
DC
made in your favor.
In 2018, I made the full disclosure of that judgment. When I went through the forms, I didn't consider it to be embarrassing, or I didn't consider it to be anything that I needed to restate, because I've already said so before in 2018.
So you have previously made a disclosure to the JSC?
Yes,
All right.
in April
Okay.
of 2018.
Okay.
Can I
Have
just say
you
something
finished,
as follow-up
Commissioner?
to the question there? Can I say something, if I may, just to complete it?
Yes, you may.
I've been acting since 2015 up until 2021. If that was an impediment from that time, then it begs the question, why am I allowed to act for so long in the High Court if people have this objection? In fact, I sat in appeals with Judge Kuhl. I've scribed 2 judgments with him, so I don't see it as an impediment, but I take the point you needed to bring it to my attention, and that's the best I can take it.
CJ, I'm sorry because of this. I would like to say, the point of Mr. Stofile here is that he raised this judgment. It has never been rescinded. The findings that he had have never been challenged. They exist. So remember, when you're an acting judge, there's no opportunity for members of the public to object to you. That's why you put so.
That's fine.
I just want to leave it here, straight to say, if you accept that there were such findings and they have been raised now as an objection.
That's fine.
Yeah.
Thank you. Commissioner Steinberg?
I just want to go back to the rape case for a moment, Mr. Maharaj. Did I hear the Premier say that you found substantial and compelling circumstances to reduce the sentence because the child wasn't harmed emotionally or physically?
That is what the Supreme Court of Appeal had indicated in terms of the seriousness of lack of injuries. They didn't prove injuries.
I'm not asking you about the Supreme
Yes,
Court.
that's correct. That's correct.
I find that astonishing. Is it possible that a 9-year-old little girl can ever come out of a rape without emotional or physical damage?
Commissioner, what the courts look for is medical evidence that had not been led by the state during the course of the trial and things like that. So that was one of the factors that was considered to be substantial and compelling, that the state did not lead evidence of the seriousness in terms of injuries to the complainant.
And you had evidence that the child didn't suffer emotional
Nothing.
harm?
Nothing. And that's evident from the judgment that was sent in the last interview.
Well,
One would expect them to have led evidence of emotional trauma, evidence of the doctor, to say this, and this is one of the serious cases. And they did it.
I'm just not sure if you need evidence when you have a 9-year-old little girl. May I just ask one more question?
Yeah.
The review from AFT is
So that,
the
beg your
review,
pardon?
the review from Advocates for Transformation, which you would have seen.
That's correct.
Yeah.
I follow you.
It's concerned that you have very little civil law experience. So I want to ask you, sitting in that division, if you got, for example, allocated a case which was challenging a tender that the municipality or, the
Public management,
made,
finance.
how would you feel confident to approach it? How would you approach it?
I would approach it on the basis of the papers. I would research the law relating to the Public Finance Management Act. So while I agree with you, the issue of civil was minimal. I think it was 2 months in total. I managed to get the statistics for the civil work done. But I would approach it on that basis, that I would read the papers, follow what's in the heads of arguments, research the law relating to that, and then make a determination. I must also appreciate, Commissioner, that when you're invited to the High Court, the Judge President will tell you, listen, I need you to go to the Circuit Court to do crime. I need you to do the backlog of crime. So I would do that. It's only in the last couple of months where you do crime, you do appeals, then you would get opposed or special opposed, or you get a civil trial. So I was invited primarily to clear backlogs in terms of the criminal matters. So I agree with you, 2 months may seem compared to criminal work, but I believe that you can still make a determination on the papers and research.
What is the law, which law do you use when an applicant brings a review, say of a tender?
In terms of the Public Finance Management Act or the Municipal Finance Management Act? I would get that information from the papers. But I haven't done with cases dealing with tenders, as it were. Or hasn't been one brought before me to say, listen, you must consider whether this tender was lawfully granted or not.
So you're not aware of the promotion of Administrative Justice
I know
Act?
PAJA, Promotion of Just Administration Act, I'm aware of that.
All right. Okay, thank you.
Any questions from the virtual platform?
Yes, DCJ.
Go ahead, Commissioner Bernard.
Thank you. Mr. Maharaj, when it comes to judicial temperament, what are your strengths and what are your weaknesses?
It's a good question, Commissioner. I think my strength lies in the fact that I keep an open mind about everything. My weakness would be, if I had to say that, would be that as a result of, punctuality, because I go to work at between 6:30 and 7 and court starts at 9, I expect the parties to be there. So sometimes litigants or witnesses or maybe even the attorneys may be reprimanded for coming in late. But of recent, I decided I'll go to court at 9, write in the court book the reasons why we cannot start at 9 and leave it at that. So insofar as that temperament is concerned, I think I've toned down trying to insist people be at court at 9 o'clock because the dynamics are different nowadays in terms of traffic, in terms of transportation, etc. So that would be my weakness and that would be my strength.
Thank you, Deputy Chief Justice. May I follow up just with a further question?
Yes.
On the same issue?
Yes.
Yeah, so have you ever been abrupt or angry or lose your temper in court? Because I notice advocates for transformation say that you've not quite acquired the abilities and temperament necessary for appointment to the bench.
No, I don't understand the temperament. Your temperament is referring to your behavior. I've been in the High Court, as I said, from 2015. I've never had any written complaints to the Judge President or to the Magistrates Commission or to the JSC while acting, or even for that matter in the regional court. So I don't know where they come with the temperament. Perhaps they interpret firmness to be temperament or something that's deserving of censure. I don't know. So in the absence of a particular complaint specifically referring to whether I insulted someone openly, it's difficult to say. Just to follow up on that, if you look at the BLA or you look at the nomination for Mr. Ori, one of the assessor who sat with me, it gives a different picture of being polite or being courteous. So ATF says temperament in the wide sense of the word. So I think I've mellowed in time. I think my patience is fine. And I do the best I can, but I've never insulted people or been abrupt to the extent where you humiliate someone or violate their dignity. So I've never had any complaint, written or otherwise, against
Thank
me
you.
for that.
Follow-up,
Thank you.
DCJ?
Yes, you may follow up.
Judge, I'm a little bit unsettled in relation to the question that was posed regarding your civil experience. I mean, in all fairness, yes, you ought not to be punished for not knowing all the areas of law. But I thought if somebody challenges you on your experience of civil law, at least your starting point, even if that is not civil law in itself, because it does deal with some parts of criminal law as well, is the Uniform Rules of Court and the Superior Courts Act. To say, look, I'm going to familiarize myself with the working framework of the space where I work. Then anything else I can research. And I mean, when you look at the Uniform Rules of Court, Rule 53 deals with the very same question that she was dealing with. Before you even go to Paja and all those things, you need to prepare a record and so forth in terms of tenders. I was just concerned about that. It's just a comment. You need not
No,
to.
that's fine. Thank you. I appreciate that. Thank you, Commissioner.
Thank you very much, DCJ.
Thank you. Any further questions from the virtual platform?
No, not from me, Deputy Justice President. Thanks.
No, thank you.
Oh, I forgot about you, Commissioner Batolondlet.
Thanks.
Please put your question.
No,
Oh, so she has
Deputy
nothing. Oh. All right, then that means no further questions for you, Mr. Maharaj. Thank you so much for making yourself available for the interview.
Thank you,
You are
DCJ. Thank you,
excused.
Commissioners, for your time.